Welcome, everyone, to the deep dive. Have you ever paused to consider how the wealth, the land, or even those treasured family heirlooms get carefully passed down through generations, protected, managed, sometimes over centuries?
It often looks pretty straightforward on the surface, doesn't it? Like maybe just a will handling everything.
Exactly. But lurking beneath that calm exterior are some incredibly complex legal structures.
Hmm.
They're designed not just to transfer assets, but really to navigate the unpredictable currents of life itself.
Mm-hmm.
Today, we're plunging headfirst into that often hidden world,
Hmm.
the surprisingly dramatic and, well, profoundly important law of trusts.
That's right. And our deep dive today isn't based on some modern legal textbook, but on truly foundational material. We're looking at excerpts from a historical legal treatise titled Llewelyn's on Trusts, specifically from its 1888 publication.
1888, that sounds like ancient history.
It does, but what's remarkable is that this text offers an incredible window into enduring principles that still shape how we think about financial and family planning today. So it's a powerful testament to the longevity and adaptability of these core legal concepts. Many of them remain fundamentally unchanged despite, all the time that's passed.
So our mission today is to demystify these, let's face it, dense legal concepts. We want to pull out the most crucial insights and maybe reveal some truly surprising facts about how trusts actually function.
Yeah, think of it as a shortcut.
Exactly. Your shortcut to being genuinely well-informed on a topic that at first glance might seem impenetrable.
Mm.
It's all about understanding the intricate dance of who gets what, when they get it, and under what conditions.
And who's pulling the strings behind the scenes, the trustees?
Right. It's a story of foresight, unintended consequences, and the law's remarkable capacity to adapt over time. Okay, let's unpack this right away. Our source material, Llewelyn's on Trusts, dives directly into a concept called portions. What exactly are these, and why were they such a central, almost foundational concept in the historical law of trusts and family settlements?
Right. Well, portions are essentially financial provisions, often quite substantial sums actually set aside from a family estate.
No.
They were almost always designated for children, particularly those who weren't inheriting the main family estate, the younger children.
Ah, okay, so not the main heir.
Precisely. These provisions were typically established through formal legal instruments like marriage settlements or wills. They were designed to ensure that all members of a family, not just, say, the eldest son inheriting the big house and lands, received some form of financial security.
Makes sense. Spreading the wealth a bit.
Exactly.
Yeah.
The underlying intent was to provide an equitable provision for those not designated to succeed to the principal family property, often daughters or younger sons, allowing them to maybe establish their own households or start careers.
Especially important back then, I imagine, when inheritance rules were pretty rigid.
Incredibly important, yeah, especially with primogeniture being so common where the eldest son got almost everything. Portions were a way to soften that.
And the text immediately highlights a significant challenge with these portions, something it calls the portionist's dilemma. Can you walk us through that? It sounds like there were some pretty tough choices involved for the estate.
Oh, absolutely. The portionist's dilemma is a fascinating tangle. It arises particularly when these portions are charged on reversionary interests.
Reversionary interests, meaning the money wasn't actually available right away.
Exactly. The funds were tied up in an estate or property that would only become accessible in the future. Say, after the death of the tenant for life, often the parents, who might have the right to live on the estate or receive income from it for their lifetime.
Okay, I see. So the money's promised, but not there yet.
Right. And this situation presented two very difficult, almost agonizing choices. The source spells them out starkly, and it reveals this deep tension within trust law.
So on one hand, the existing estate could take a significant hit. Like you said, selling off the family silver at a discount.
Precisely. That's one choice. The estate must suffer by raising the portions at a sacrifice in presenti out of an interest to take effect in future.
Okay, break that down a bit.
Imagine a landed estate, maybe with a future inheritance tied to it. If money for a daughter's marriage portion needs to be raised now, but it's tied up in assets that won't fully mature or become liquid for years.
Like timber that's not ready to cut, or land they don't fully control yet.
Exactly. You'd likely have to sell that future interest or borrow heavily against it, probably at a significant discount. This forced the estate to sacrifice a considerable amount of its present value.
Which could hurt the current generation or even the long-term health of the estate itself.
Absolutely. It was a direct trade-off between the immediate need of the portionist and the long-term stability of the main family asset.
And the alternative choice was equally grim, but for the portionists themselves.
Indeed. The second choice was that the portionists must be left destitute until the reversion falls into possession.
Destitute, wow.
It sounds dramatic, but it could be very real. This meant the children who might be coming of age, planning to marry, needing capital to start a business, would be left without that promised financial support for potentially years or even decades until, mom and dad passed away and the main estate became fully available.
Leaving them in a really precarious financial state, unable to get on with their lives, even though the money was technically promised to them.
Exactly. Despite the clear and compassionate intent of the settlement, so the law and the courts had to meticulously navigate this tension. It was about protecting the long-term estate versus providing for the beneficiaries in a timely, responsible way.
It's a balancing act that, like you said, probably still echoes in financial planning today, thinking about liquidity versus keeping assets intact.
Definitely. When do you cash in versus letting something grow? Same basic tension.
That's a real pickle.
Yeah.
It really highlights how these legal structures aren't just abstract rules, but about solving very human problems and dilemmas. The text also mentions some surprisingly diverse modes of raising portions. We're not just talking about selling land, are we?
Not at all. And this is one of those charmingly surprising details in the treatise that really paints a picture. While sale or mortgage were, of course, common methods, like, liquidating or borrowing the text lists some fascinating alternatives.
Like what?
Beyond buy, sale, or mortgage, it specifically mentions raising portions by a fall of timber.
A fall of timber, so chopping down trees.
Well, yes, but probably more managed than that sounds. It refers to the systematic felling and sale of mature trees from the estate's woodlands. It implies a managed resource, harvested strategically to generate funds without selling the actual land.
Okay, sustainable forestry meets trust law.
Sort of. And even more intriguingly, it mentions raising portions out of mines, implying that mineral rights or the proceeds from mining operations on the land could be tapped.
Wow, so they really looked at every possible asset the estate held.
Absolutely. It illustrates the comprehensive, sometimes creative ways estates were managed to fulfill these provisions. It shows this integrated view of wealth, where the land wasn't just, the surface, but a layered source of different kinds of capital.
So the immediate insight here is that historical trusts were incredibly practical, adapting to whatever resources an estate had its timber, its mineral wealth to fulfill family obligations. And speaking of family, here's where it gets really interesting.
Yeah.
When it came to who qualified as a younger child, the law, particularly the Court of Chancery, didn't always stick to the literal definition. Our source talks about the court exercising a prodigious latitude of construction. What was behind this flexibility?
Ah, yes, this is a crucial point. It highlights the court's pragmatic and, frankly, deeply purpose-driven approach to trusts, especially in family settlements. The core principle, as the text puts it, was that the court, in the case of portions, seems to have regarded rather the purpose than the words of the instrument.
So intent over literal meaning.
Exactly. Instead of getting bogged down in the strict literal definition of words like eldest or younger, the court focused on the settler's underlying intent. What was the point of setting up these portions?
Which was usually to make sure everyone got provided for somehow.
Right. The goal was to ensure the overall provision for the family was met fairly and equitably, that no one was inadvertently left out or, crucially, received an unintended double portion, getting both the main estate and a chunk meant for a younger child.
It's a remarkable demonstration of equity, of fairness, sort of softening the hard edges of strict legal interpretation.
Precisely. It was less about rigid definitions and more about ensuring the spirit of the settlement was upheld, even if it meant bending the literal meaning of words like younger child.
Do we have a good, maybe even a dramatic example of this from the text, how this played out in a real case?
We do, and it's a classic illustration, the case involving Humphrey and Thomas. Picture this. A family settlement designates a portion, let's say £4,000, for the younger children. Humphrey is the eldest son, destined to inherit the main estate. Thomas is the second son, clearly a younger child, when the settlement is made. The father initially appoints £2,600 of this portion to Thomas when he gets married. Makes perfect sense.
Seems straightforward so far.
But then tragedy strikes. Humphrey, the eldest son, dies without issue during his father's lifetime.
Oh. So Thomas, who was unequivocally the second son, suddenly finds himself the eldest son and heir to the entire estate. That's quite a twist.
Exactly. A complete game changer in the eyes of the court. The father, responding to this unforeseen event, then tries to appoint that £2,600 to his other younger children, specifically excluding Thomas.
And did the court allow that, even though Thomas was a younger child when the money was first earmarked for him?
Yes, it did. The court judgment affirmed the exclusion. Thomas was deprived of any share in the portion for younger children, despite literally being the second son, because he now took the main estate.
On what grounds?
It was based on an implied condition. The idea was that the portion was implicitly conditional on him, not afterwards becoming the eldest son and heir. The court reasoned that no one should, under the same settlement, take the estate and a portion also. The law, driven by the settler's presumed intent, sought to prevent an accidental windfall.
That's fascinating. It's almost like the law was correcting for fate, preventing someone from getting an unfair advantage due to a change in circumstances, even if, on paper, they once perfectly fit the definition.
You've hit it exactly. The insight here is that the law of trusts prioritizes the purpose providing for the family fairly over just literal wording. It reflects a deeper, almost human understanding of fairness in inheritance.
So the court would disregard the strictly literal meaning of the words eldest and younger to uphold that underlying intent.
Precisely. The aim was to ensure each family member had a provision, but not a double benefit. To prevent an eldest son, who got the main estate, from also grabbing a younger child's portion, and this applied quite broadly.
Even if they didn't get the estate directly from the person who set up the portions.
Yes, as long as the overall intention was clearly to provide for the family through that combination of the estate and the portions. The text stresses that where the settler is the parent, or acting in loco parentis, standing in the place of a parent, this prodigious latitude applies most strongly, because the presumed intent is clearly parental provision for all children appropriately.
Okay, so what does this all mean for the beneficiaries themselves? When does their right to a portion actually become concrete or vest in legal terms? Because it sounds like getting the money isn't necessarily the same as having a right to it.
That's a crucial and often confusing distinction. The usual period for a portion to legally vest for the right to become legally theirs was pretty clearly defined.
How so?
For sons, it was typically upon attaining 21 years of age. For daughters, it was either at 21 or upon marriage, whichever came first. This vesting meant the right to the money became legally theirs, a concrete asset they owned.
Okay, so at 21, it's legally mine.
Yes. However, and this is the crucial link back to the portionist dilemma, these portions were often not to be payable until after the death of the tenants for life.
Meaning the parents, usually.
Often, yes, or whoever had the life interest. Unless, the text adds, with their consent. So, a child might have a legally vested right to a portion at 21. It's legally theirs. It can even be passed on to their own heirs if they died, but they couldn't actually access the cash until potentially much later, maybe decades later, after the life tenants passed away.
Can you give us a concrete example of how this played out? The text mentions a case that clarifies this.
Yes. Consider the example involving Peter and Elizabeth, who had 2 children, John and Mary. A fund was established, with portions designated for children attaining 21.
What?
John hits 21, so his portion vests. But sadly, he dies while his mother, Elizabeth, is still alive. She's the life tenant.
So the money wasn't payable yet.
Correct. But despite his early death and the fact the money wasn't yet payable, his personal representative, that is, his estate, was still legally entitled to his portion. It shows that once vested, the portion was considered a concrete asset, a true property right, even if the actual payment was delayed.
The right existed independently of the payout date.
Exactly. And the court emphasized this wasn't arbitrary. It had to be based on a natural and plain reading of the settlement's wording about survivorship, always trying to respect the settler's genuine intent. The insight here is the law's ability to separate the right to property from the immediate enjoyment of it, creating these sophisticated layers of ownership over time.
That brings us to another important concept mentioned, ademption and satisfaction, which seems to be all about avoiding double portions. How did the law prevent someone from inadvertently or intentionally getting more than their fair share, particularly from a parent?
Right. The law, especially equity, has this strong leaning against double portions. The underlying idea is that a parent, acting out of a desire to provide fairly for their children, generally intends to give them one substantial provision, not multiple, redundant, or excessive ones. It assumes a consistent parental desire to be equitable.
So, if dad promises money in a settlement, then gives a similar amount later.
The law presumes he means it as the same provision. For example, if a father covenants in a marriage settlement to give his daughter, say, £1,000, and then later, either during his lifetime inter vivos or in his will, gives her another £1,000, the court presumes this second gift is meant to be the same provision or a substitute for it, not an additional one piled on top.
So she wouldn't automatically get both unless there was very clear, undeniable evidence that the father intended for her to have both. Like he explicitly said, this is extra.
Precisely. And this is where the terms ademption and satisfaction come in. Ademption is specifically where a provision in a will is considered revoked or redeemed by a later lifetime gift that serves the same purpose.
Like the example you gave. The will says £1,000, then he gives £1,000 during his life. The will part is canceled out.
Exactly. It's deemed the gift was already given. Satisfaction is a broader concept where a prior legal obligation, like that covenant in the settlement to provide money, is considered fulfilled or satisfied by a later gift, whether made during life or by will.
And what happens then? Does the beneficiary just get the later gift?
Usually the beneficiary is put to her election. She has to choose between the original settlement promise and the later gift. She can't claim both unless the settler's intention for double portions is explicitly and undeniably clear in the written instrument itself. The law tries to fulfill, not duplicate, the parent's generosity.
What about external evidence, like verbal statements or other circumstances? Can parole evidence be used to prove intent for double portions or maybe to rebut this presumption against them?
This is where it gets subtle, and the source clarifies the role of parole evidence, that's oral or extrinsic evidence, stuff not written down in the legal document. It cannot be used to contradict a written instrument if that instrument already clearly shows an intent for double portions. The written word rules there. However, if the written instrument is silent or ambiguous, and the presumption against double portions kicks in, then parole evidence can indeed be used to rebut that presumption.
So you can bring in evidence that dad said, look, this extra 1,000 is on top of what's in the settlement.
Exactly. Evidence like that might show the father explicitly intended the second gift to be in addition to the first. And conversely, counter evidence can be presented to fortify the original presumption against double portions.
So it's all about getting to the true intention.
It really shows the court's deep concern with ascertaining the true, albeit sometimes unstated, intention of the settler, especially when providing for family, while still trying to maintain the integrity of written legal documents. It's a constant balancing act between the letter of the law and the spirit of the gift.
Beyond just managing the money, a core principle in trust law is the trustee's role as a fiduciary. This is a concept that extends far beyond trusts, right, into finance directorships.
Absolutely. It's fundamental to many positions of trust and responsibility.
So what's the golden rule that defines this role, and why is it applied so strictly, almost unforgivingly, in law?
The golden rule for trustees, and indeed for any fiduciary, is straightforward but incredibly strict. He who undertakes to act for another in any matter cannot, in the same matter, act for himself.
Cannot act for himself. Full stop.
Full stop. This principle is absolutely fundamental to preventing conflicts of interest and ensuring unwavering, undivided loyalty to the beneficiaries, the Sestuki Trust. The trustee's paramount duty is always, always, always to act in the absolute best interest of the beneficiary, never their own, and never in a way that even appears to prioritize self-gain. It's a bedrock principle of integrity.
And what's the rationale behind such an unyielding rule? It seems incredibly harsh, especially if a trustee believes they are acting in good faith, maybe offering a fair price for something.
The rationale is rooted in the inherent power imbalance and, crucially, the informational advantage a trustee holds. The trustee gains intimate knowledge about the property, its true value, its hidden potential, its vulnerabilities, maybe opportunities for growth or sale.
Knowledge they wouldn't have otherwise.
Exactly. They acquire this knowledge at the expense of the Sestuik Trust simply by being put in that position of trust. Therefore, the law says they are bound to apply it for the Sestuik Trust's benefit.
And if they could profit personally.
If a trustee could profit, even indirectly, from this knowledge or their position, it would create an almost irresistible temptation to prioritize self-interest over the beneficiary's welfare. It would fundamentally undermine the very foundation of trust. The law prefers to err on the side of absolute purity in this relationship, recognizing the subtle, even subconscious psychological pressures at play. It's about eliminating even the potential for bias.
So what are the practical implications of this no self-dealing rule? Does it mean a trustee can literally never buy property from the trust, even if it's at a public auction for a fair market price?
That's exactly what it means, practically speaking. The implications are exceptionally stringent. A trustee cannot, under virtually any circumstances, buy trust property. This applies even if it's offered at a public auction where you might think, well, that's fair market value. Doesn't matter.
Even through an agent?
Nope. Can't use an agent either. They also cannot lease trust property to themselves or their partners. The mere appearance of impropriety is often enough to void the transaction, regardless of the actual honesty or the fairness of the price.
Wow.
The law takes this stance because it's incredibly difficult, if not impossible, to objectively prove whether the trustee genuinely acted only in the beneficiary's best interest or subtly manipulated the situation consciously or subconsciously for personal gain. The rule is designed to prevent not just actual fraud, but the very opportunity for it.
Are there any limited exceptions to this incredibly strict rule? It sounds like it could create difficult situations sometimes, maybe where the trustee is genuinely the best buyer.
There are indeed very narrow circumstances, but they are rare and heavily scrutinized by the court. A purchase by a trustee might be allowed if, and this is a big if, all beneficiaries, provided they are of full age and capacity, explicitly consent to the transaction.
After full disclosure, I assume.
Absolutely. After full and complete disclosure of all relevant facts, and critically, the trustee's personal interest in the deal. And even then, the court watches such bargains with exceeding jealousy. It looks for any hint of undue influence or pressure.
So no forcing the beneficiaries to agree.
Definitely not. The other rare exception is if the purchase is explicitly sanctioned by the court itself. This might happen in unusual circumstances where it's demonstrably in the trust's best interest and no conflict can really arise. Lord Eldon, a famous judge, noted cases where a trustee's purchase was enforced because there was that explicit, well-informed consent from everyone. But the default position, the starting point, always remains no self-dealing. The insight here is profound. A true fiduciary relationship demands putting the other party's interests first without exception.
Okay, let's shift to selling trust property. Especially large or complex estates, that can be a monumental affair. What are the key duties and restrictions placed on trustees when they're tasked with a sale, according to our 1888 source?
Right. When trustees have to sell property, they operate under very specific guidelines. The main goal is always to ensure they obtain the absolute best outcome for the beneficiaries. Now, generally, they can proceed with the sale without getting prior court sanction.
So they have some autonomy.
They do, which implies a degree of trust in their judgment. However, there's a critical caveat that really underscores judicial oversight. If a suit has been instituted for the execution of the trust, meaning the trust is already under formal court supervision, maybe there's a dispute about it.
Then the court gets involved.
Then the situation changes dramatically.
Yeah.
That attracts the jurisdiction of the court, and the trustees are then not justified in proceeding to a sale without the court sanction. It ensures judicial oversight when things are already formally in the court system, adding a layer of protection.
Okay, so even if they don't always need court approval, how do they go about getting the best price for the property? Is there a recommended strategy mentioned to maximize value?
Yes, the text mentions the usual course for obtaining the highest possible price, and it's quite insightful, maybe a bit counterintuitive.
How so?
It's often suggested that the beneficiaries, who obviously have the strongest personal motivation to get top dollar because it's their money, should be the ones to enter into a conditional contract with a potential purchaser.
The beneficiaries make the deal first.
Sort of. They line it up. Then the trustees step in to obtain the assent of the trustee who, when he has satisfied himself that the sum proposed is fair and truly represents the best value for the trust, then they can approve the contract.
Ah, I see. It balances the beneficiary's drive with the trustee's duty to be prudent and objective.
Exactly. It's a clever way to leverage different strengths, the beneficiary's market sense and motivation, and the trustee's fiduciary responsibility, all for the trust's benefit.
When it comes to the actual act of selling, how much can a trustee delegate? Can they just hand it all over to an agent or a solicitor and, wash their hands of it?
No. This is a point of strict limitation and often a trap for unwary trustees. The trust for sale itself, meaning the core decision and ultimate responsibility for the sale, cannot without responsibility delegate. The buck stops with the trustee.
They have to stay in control.
They must retain ultimate control and decision-making authority. However, they can employ agents for tasks that are conformable to the common usage of business, as long as the trustee acts as prudently for the beneficiaries as they would for themselves.
Like hiring a real estate agent.
Exactly. Hiring an agent for marketing, showing the property, that's fine. But the trustee still signs the final documents, makes the strategic decisions, and crucially, the source emphasizes that an agent for sale must not be allowed to receive the purchase money.
The money goes directly to the trustee.
Yes, that remains the trustee's direct, non-delegable responsibility. And interestingly, another specific point. The trustee's solicitor ought not to choose the valuer, the person who assesses the property's worth.
Why not? Conflict of interest again.
Precisely. To avoid any potential conflict or undue influence, these specific rules really highlight the meticulous, careful nature of trustee duties. It's not a casual role.
Definitely not. What about the specific terms and conditions they can impose on a sale? Are there boundaries there, or can they just add anything they want to the contract?
There are boundaries. Trustees are allowed to use reasonable conditions of sale, which is fairly broad. But, and this is key, they are not justified in clogging the property with restrictions that were evidently uncalled for by the state of the title.
Meaning they can't add weird or burdensome conditions that might scare off buyers.
Exactly. They can't add unnecessary, arbitrary, or overly burdensome conditions that might deter buyers or unfairly reduce the property's value. You know, like insisting on some obscure ancestral right that makes the title murky.
Okay. But things evolved here, too.
Yes, the text notes that later legislation, part of that broader move towards modernizing property law, like the Conveyancing and Law of Property Act, 1881, actually enabled trustees to insert a wider array of stipulations. It simplified the process, allowing for more standard commercial practices, as long as they were reasonable and in the trust's best interest. It was about making trust sales more efficient, but always protecting the trust.
The source also touches on selling specific assets, like timber or minerals, separately from the land itself. Was that always straightforward, or was there historical resistance to dividing up a property like that?
No, historically there was significant sensitivity and legal resistance. Before key acts were passed, the surface of the land could not generally be sold apart from the minerals beneath it or the timber on it. They were considered integral, indivisible parts of the property.
A more traditional, holistic view of land ownership.
Right. But after 1859, legislation like the 25 and 26 Vict 108 introduced a crucial change. Trustees were authorized, but with the previous sanction of the Court of Chancery, to sell the surface separately from the minerals.
They still needed the court's permission.
Yes, they had to get a court order, typically obtained in a summary way. It shows the court's careful oversight of potentially complex divisions of property. It marked a shift towards a more, let's say, economically utilitarian view of property, allowing for the monetization of specific assets within a larger estate.
And what about succession duty, essentially, and inheritance tax? Does selling trust property free it from future tax obligations for the purchaser? That seems important.
Yes, the source clarifies this. A sale by trustees can indeed give a good title to the purchaser free from succession duty.
How does that work?
Because the duty attaches on the interest of the successor, the beneficiary inheriting the value. When the property is sold, that beneficial interest is converted into the money in the hands of the trustees, not the land itself. So the sale occurs under a title that is paramount to the succession duty.
So the tax liability follows the money, not the land.
Exactly. It effectively shifts the tax burden from the land to the monetary proceeds held by the trustees, who would then have to account for it. This was a significant practical advantage for buyers of trust land, removing a potential future headache.
Finally, on sales, what about the specific language used in the conveyance, the legal document that actually transfers ownership? Did that matter for trustees, or was it just standard legal boilerplate?
Oh, it mattered historically quite a bit and still holds subtle importance. The word grant in conveyances was once, apparently erroneously, thought to contain an implied warranty of title.
Meaning the trustee might be on the hook personally if there was a problem with the title later.
Potentially, yes. So to protect themselves, trustees were often made to bargain, sell, and release the property instead, carefully omitting the word grant. And even with those changes, trustees typically insist on including very specific protective covenants in the deed.
What do these covenants do?
They're designed to limit the trustee's personal liability. They essentially say the trustee is only responsible for their own actions as trustee, that they haven't personally done anything to encumber the title, but they aren't guaranteeing the title against claims arising from before their time or from others' actions. It's crucial for shielding trustees from unforeseen future claims, allowing them to do their job without fear of personal financial ruin for issues beyond their control. The underlying insight, maybe, is that liability shakes action, And good law tries to balance responsibility with appropriate protection for those doing the work.
Okay, here's a really crucial point for anyone dealing with trust property. How does a purchaser know their payment actually frees them from further responsibility? When is a trustee's receipt considered sufficient and a complete discharge, meaning the buyer can walk away confident they're done?
Right, this is an area where the law underwent significant and, frankly, profoundly beneficial simplification. It moved from a really complex and risky landscape for buyers to one of much greater certainty.
What was it like historically?
Historically, the burden on purchasers could be considerable. If you bought property from a trust, you sometimes had an active duty to ensure that the purchase money was properly applied by the trustee.
Wait, the buyer had to make sure the trustee did their job properly with the money?
Sometimes, yes. This was especially true if the trust was for specific, defined purposes, like paying a named individual a legacy or settling a specific debt. The logic was, if the money was meant for person X and the purchaser knew this, and the trustee then misused the money, the purchaser could potentially be held liable for the trustee's misconduct.
That sounds like a purchaser's nightmare. You'd have to investigate the trust itself before buying.
It added a huge, almost impossible layer of due diligence to every transaction. It could really slow down commerce. And there was always the risk of outright collusion between the trustee and purchaser, which would obviously invalidate the discharge.
Okay, so how did it get simpler?
Thankfully, acts like the Conveyancing and Law of Property Act, 1881, revolutionized this. This act significantly simplified the process by unequivocally stating that the receipts in writing of any trustees or trustee for any money are made sufficient discharges.
Meaning the trustee's signature on the receipt is basically enough?
Pretty much. Once a trustee signs a receipt acknowledging payment, the purchaser is generally no longer responsible for seeing how the money is used by the trustee. The burden shifted entirely onto the trustee, where it arguably belonged.
And this applied broadly.
Yes, this protection applies to trusts created both before and after the Act came into force, providing a much-needed layer of security and efficiency for buyers of trust property. It really transformed property transactions by removing a massive historical hurdle.
So the burden shifted entirely to the trustee. What about executors dealing with wills? Did their receipts historically offer the same level of protection, or were there different rules for them?
Executors' receipts generally provided even stronger indemnity to purchasers, actually.
Why was that?
Largely because executors were assumed to be selling property primarily to pay the deceased's debts. Paying debts is a primary obligation of any estate and often requires liquidating assets. So even if the property was specifically bequeathed to someone in the will, the purchaser was usually protected by the executor's receipt, provided they acted in good faith.
Unless there was obvious fraud.
Exactly. That protection was lost if there was legal evidence of fraudulent intent on the part of the executor. For example, if it was clear they were selling assets to pocket the money for their own private purposes rather than for the estate's benefit. In such a scenario, the purchaser might be implicated if they had actual or constructive knowledge of the fraud.
So if I'm buying from a trustee today and I get a valid receipt, I can generally rest easy knowing I'm in the clear and don't have to chase the money around to see if it's used properly?
That's the crucial takeaway, yes. And it represents a monumental shift in legal principle. We went from a complex buyer beware approach, where the purchaser might have had to oversee the application of funds, to one where the trustee's receipt is generally conclusive. It places the burden of proper application solely on the trustee, the fiduciary directly responsible. It significantly streamlines transactions, provides far greater security for purchasers, and highlights the law's evolving role in balancing protection with practical commercial reality. It's a fantastic example of how legal reform can really unlock economic efficiency.
Okay, let's switch focus to the cestuicu trust, the beneficiary, the person for whom the trust is actually created. They aren't just passive recipients waiting for money, right? They have powerful rights. What are the key ways they can assert control and demand transparency from their trustees, according to our historical source?
Absolutely. The beneficiary's rights are robust, rooted in the very nature of equity, and transparency is paramount. The first and most fundamental right flows from the bounden duty of the trustee to keep clear and distinct accounts of the property he administers.
Bounden duty sounds serious.
It is. This isn't just a suggestion. It's a core, unwavering obligation. Failure to keep proper accounts exposes the trustee to great risks, including personal liability. Accurate and transparent accounts are absolutely essential for the beneficiary's beneficial enjoyment of their interest.
They need to know what's going on with their assets.
Precisely. What's been sold, what debts paid, what income received, how the funds are invested and managed. Without clear accounts, a beneficiary is effectively flying blind, unable to hold the trustee accountable.
So those accounts are non-negotiable. What if a beneficiary wants more than just information? What if they want to take direct control of the trust property, maybe end the trust over a specific asset? Can they compel the trustee to just hand over the legal title?
Yes, they often can. This is known as the jus disponendi, the right of disposal, and it's one of the most powerful rights a beneficiary holds. A beneficiary has the right to call upon the trustee to execute conveyances of the legal estate as the cestui quo trust directs.
So tell the trustee to sign the property over.
In simpler terms, yes. If the beneficiary is absolutely entitled to the property, meaning there are no conditions left to be met, no other beneficiary's rights involved, and they are of full age and capacity, they can demand that the trustee transfer legal ownership of that asset directly to them or to someone they nominate.
And if the trustee refuses?
If the trustee refuses without a valid, legally justifiable reason, the beneficiary can sue them to compel that conveyance. It effectively ends the trust relationship over that specific asset and gives the beneficiary direct control. It's a potent tool for autonomy.
That's a powerful right. But what if the beneficiary is requesting a transfer that seems, well, suspicious? Perhaps it looks like it's designed to defraud other beneficiaries. Or it just seems questionable to the trustee. Does the trustee have a right or even a duty to investigate further before simply complying?
Yes, they do, and this highlights that constant balancing act the trustee performs. Trustees have a right, and sometimes a solemn duty, to investigate if they genuinely suspect a fraudulent appointment is being made, especially if it appears to unfairly diminish the rights or interests of other beneficiaries under the trust.
So if it looks like someone's trying to pull a fast one?
Exactly. If an appointment of a portion or a distribution seems designed to benefit someone not intended by the original settlor, or to unfairly deplete the share of others, the trustee can and should scrutinize it.
Yeah.
However, and this is important, the threshold for refusal is high.
They can't just refuse on a whim.
No. A mere possibility of fraud or just a general unsubstantiated suspicion isn't sufficient grounds to refuse a conveyance if no actual malefides bad faith or dishonest intent on the part of the beneficiary making a request can be proven. The trustee needs solid, demonstrable grounds, not just a hunch, to withhold the legal title. Otherwise, they risk being sued themselves for obstructing the beneficiary's rights. It's a testament to the law's demand for clear evidence, even when dealing with potential wrongdoing.
Okay, shifting gears slightly. Can a beneficiary sell or transfer their interest in a trust, even if it's not yet in possession? Like, if it's a future right or seems uncertain, maybe contingent on someone else dying? How do these equitable interests behave in the market?
Yes, this is a fascinating aspect of equitable interests and really shows their inherent nature as a form of property. The general rule is that an equitable interest may be assigned, though it be a mere possibility.
Even a mere possibility.
Even a possibility. This means even a future contingent or uncertain right to receive benefits from a trust, like a right that will only materialize if you survive your aunt or reach age 30, can be legally transferred or sold.
How does that work? Does a trustee need to be involved?
The assignment can happen either with or without the intervention of the trustee. The assignee, the person who receives or buys this interest, essentially steps into the shoes of the original beneficiary. They acquire the same rights the original beneficiary had, and can even compel the trustee to transfer the legal estate once all the conditions are eventually met.
So these future benefits, however distant or uncertain, have real marketable value, like a kind of futures contract for inheritance.
That's a good way to think about it. It means these interests can be used as collateral, sold for cash, or passed on in other ways.
But if someone buys an equitable interest like this, do they take it free and clear? Or are there any strings attached from the original beneficiary's past dealings or debts related to the trust?
This brings us to a critical principle that protects the integrity of the trust and other potential claimants. The assignee of an equitable interest is bound by all the equities affecting it.
Bound by the equities. What does that mean in practice?
It means the person receiving the assigned interest takes it subject to any pre-existing claims, set-offs, or liabilities that the original beneficiary might have had against the trust or other parties relating to that interest.
Can you give an example?
Sure. Let's say the original beneficiary owed money to the trust fund, maybe from an advance they received earlier, Or perhaps there was another valid charge or claim on their interest made before the assignment. The assignee takes the interest with those burdens attached. They can't claim a better right or a cleaner interest than the person who assigned it to them. It's definitely a buyer beware principle within the world of equitable assignments. You buy what the seller actually has, warts and all.
Okay, that makes sense. So how does one establish priority if, say, a beneficiary assigns their interest to person A and then later fraudulently assigns the same interest to person B? Who gets it? Is it simply first come, first served based on the assignment date?
It's not simply chronological, which is where things get really interesting and intensely practical for anyone dealing with these equitable interests. While notice to the trustee is not necessary between the assignor and the assignee for the assignment itself to be legally valid.
The transfer is valid the moment it's signed.
Yes, between those two parties. But notice to the trustee is absolutely essential for establishing priority among multiple assignees claiming the same interests.
So notice is the key to getting ahead in the queue.
Exactly. The golden rule here, established in a famous case called Dearl v. Hall, which really incentivized diligence, is the first encumbrancer who gives notice to the trustee gains priority.
Wow. So even if my assignment was earlier, if someone else gets their notice in to the trustee first, they can jump ahead of me.
That's precisely the rule. It's effectively a race to notify the trustee. So, if you're acquiring an equitable interest, the first thing you should do, practically speaking, is give formal notice to the trustee, because failure to do so could mean losing out completely to someone who acted later but notified faster.
That sounds like it could lead to some really tricky situations, especially if there are multiple trustees and maybe they don't all communicate, or if a trustee who received notice dies. It puts a lot of ongoing responsibility on the assignee to keep track.
It absolutely does, and the source highlights these practical dilemmas. For instance, what if you give notice to only one of two trustees? If that trustee dies before the other trustee is informed, or before the information is properly recorded in the trust files, a later encumbrancer who gives proper notice to the remaining or new trustees could potentially gain priority over you.
Ouch. So the notice has to be effective and enduring.
Yes. This isn't theoretical. It highlights the ongoing, proactive responsibility for the assignee to ensure their notice remains current and effective with the people actually managing the trust. A lapse or an incomplete notification could lead to a devastating loss of priority. The insight here is that while equitable interests offer great flexibility, they also demand significant vigilance and a robust understanding of the system to truly secure your rights. It's not passive ownership.
Okay, let's talk about the trustees again. They do a lot of work, often considerable effort, and historically, as we've touched on, often without direct payment specified. What are they legally entitled to be reimbursed for? And what's that very strict rule that prevents them from personally profiting from their position?
Right. First, let's be clear on entitlements. Trustees are unequivocally entitled to be reimbursed from the trust property for all expenses properly incurred by them in the administration of the trust.
What kind of expenses?
Anything legitimate, necessary legal fees, accounting costs, property maintenance, insurance premiums, taxes paid on behalf of the trust, travel costs directly related to trust business. These expenses are considered a first charge or lien upon the estate.
Meaning they get paid back before beneficiaries get anything.
Yes, their right to reimbursement comes first. It's about ensuring they aren't out of pocket personally just for performing their duties reasonably.
But then there's that very strict no-profit rule we discussed earlier in the context of self-dealing. How does it apply to compensation for their time and effort?
The no-profit rule is a bedrock common law principle, and it extends here too. A trustee cannot profit from their trust. Specifically, this means that if a trustee also happens to be a professional, say a solicitor, an accountant, a surveyor, or a land agent, they absolutely cannot charge the trust for their professional services rendered to the trust, even if those services would normally command a substantial fee in the open market.
So a solicitor, acting as trustee, can't charge the trust for the legal work they do for it.
Not unless specifically authorized, no. This applies even if they acted with the utmost honesty, in impeccable good faith, and their expertise demonstrably saved the trust money compared to hiring someone else. The rule is about preventing the potential for conflict of interest, not just actual wrongdoing. It's an uncompromising stance on fiduciary purity.
That still seems incredibly counterintuitive, almost punishing good work. Why is it so absolute?
It does seem counterintuitive on the surface, and it's often debated, but the rationale runs deep. It's to remove any temptation, however subtle, for self-interest and ensure undivided, absolute loyalty to the beneficiaries.
So,
If a trustee could charge fees for services, there might be a subtle, perhaps even subconscious incentive to, say, prolong the trust unnecessarily, or engage in more complex transactions than strictly needed, or simply generate more billable hours. The law prefers to err on the side of absolute purity in the fiduciary relationship, to avoid any perception, let alone the reality, of self-enrichment at the expense of the trust. The primary insight remains that the law prioritizes unwavering loyalty over allowing individual financial incentives for the trustee in their professional capacity.
are there any ways around this or specific exceptions for trustees to receive some kind of compensation for their time and effort, given how much work it can be, especially for complex trusts?
Yes, there are specific exceptions and workarounds, but they are carefully delineated and often require explicit provision.
Such as?
Well, the most straightforward is if the settler, the person creating the trust, explicitly directs compensation in the trust instrument itself. This could be a fixed salary, a gross sum upon completion, or maybe a percentage of the trust assets or income.
So if the trust deed says, pay my trustee 6 days per year, that's okay.
That's generally allowed. And if the settler directs payment but doesn't specify the amount, the court may even step in to determine the quantum meruit Latin for what one has earned, basically, a reasonable fee for the services rendered.
What about agreements with the beneficiaries?
That's another path. A trustee can agree with all beneficiaries, provided they are competent adults, for an allowance or payment. However, and the source stresses this, such bargains are watched with exceeding jealousy by the court.
Meaning the court is suspicious of them.
Highly suspicious. The agreement must be freely made and not submitted to from pressure or any kind of undue influence by the trustee leveraging their position. The court wants to be absolutely sure the beneficiaries weren't coerced into agreeing to pay the trustee.
So the court is very wary of any agreement between a trustee and beneficiaries that looks like the trustee pressured them. What if a trustee incurs truly unusual expenses that aren't part of the routine administration, maybe in an emergency situation, to protect the trust assets?
That falls under the category of extraordinary outlay. If a trustee, acting honestly and without fault, incurs unusual expenses that go beyond routine administration, but are genuinely necessary to protect or save the trust, they may well be entitled to reimbursement for that outlay.
Can you give an example?
The text gives an example like incurring liabilities to tradesmen for carrying on a business associated with the trust, even without explicit authority in the trust deed, but where doing so was clearly for the beneficiary's benefit and necessary to preserve the trust assets, perhaps preventing bankruptcy. This allows for flexibility in unforeseen circumstances as long as the trustee acts prudently, honestly, and demonstrably in the trust's best interest, even if the action wasn't explicitly pre-authorized. It's a recognition that unforeseen challenges sometimes require adaptive management, provided it's genuinely for the ultimate benefit of the trust.
What happens if the appointed trustee simply fails? Maybe they die or refuse to act or become incapacitated and just can't fulfill their duties. Does the whole trust just fall apart, leaving the beneficiaries in limbo?
This brings us to a really fundamental and, frankly, comforting principle of equity. The trust is not thereby defeated, but fastens on the conscience of the person upon whom the legal estate has devolved.
Okay, fastens on the conscience. What does that mean practically?
It means the trust itself is paramount, not the specific individual acting as trustee. The trust obligations essentially follow the legal ownership of the property. Whoever ends up holding the legal title, even if it's by accident, like the heir of a deceased trustee who inherits the property, becomes subject to the trust obligations attached to that property. Their conscience is bound by the trust.
So the trust is like this separate, enduring entity that sticks to the property.
That's a great way to put it. The trust follows the legal estate. This rule only bends if the property somehow gets transferred to a bona fide purchaser for valuable consideration who has absolutely no notice, no knowledge, or reason to know of the trust. Otherwise, the trust persists. As Lord Chief Justice Wilmot famously described it, the legal estate is nothing but the shadow which always follows the trust estate in the eye of a court of equity.
The trust is the substance, the legal title, just the shadow. I like that.
It emphasizes that the trust is robust, designed to persist regardless of the individual trustee's actions or inactions.
So what's the court's role when there's a vacancy, or when trustees simply fail to act on a specific instruction in the trust?
The court actively intervenes to ensure the trust's execution doesn't fail. For instance, if a will directs property to be sold but maybe forgets to name someone to actually carry out the sale, the executor of the will can often step in and sell, acting as an implied trustee for that purpose.
And if existing trustees just don't do what they're supposed to?
If trustees fail to act on what's called a power imperative, that is, a power that the settlor clearly intended must be exercised, it's not purely optional, the court will step in and ensure it's performed. The trust won't be allowed to fail simply because of a trustee's inaction or absence. The court acts as a crucial backstop, always aiming to uphold the settlor's intentions.
Does the court ever substitute its own judgment for the trustee's discretion, though? Or does it only intervene when there's a clear failure to act on something mandatory? Is there a line the court won't cross?
This depends critically on the nature of the discretion given to the trustee by the settlor. If the settlor has prescribed a clear rule laid down for the trustee's discretion, for example, a trust to benefit the poor, where the context makes it clear poor means actual poverty and necessity, then the court will intervene if the trustees fail to exercise that discretion, or if they exercise it improperly, say by giving money to wealthy relatives. The case of Gower v. Mainwaring is cited as an example where the court stepped in precisely because a guiding rule or principle was provided by the settlor.
Okay, so if there's a guideline, the court enforces it.
Yes. However, and this is the crucial distinction, if the power given to the trustees is purely arbitrary and without any defined object or guiding rule, meaning the settlor truly left it entirely to the truster's unguided personal judgment, like to give £100 to whomever my trustee thinks most deserving, then the court generally interposes not.
It won't interfere.
It will not substitute its own discretion for the trustees as long as the trustees' conduct is bona fide, meaning they acted in good faith, however unwisely perhaps. The court respects truly absolute unfettered discretion if that's what the settlor granted. But where a rule or standard can be discerned, it will ensure compliance. This shows the nuanced way equity balances respecting the settlor's specific wishes with ensuring the trust is properly administered overall.
Charitable trusts often seem to operate under a fundamentally different set of rules compared to private family trusts. How does the law of trusts apply to them, and how does the court ensure charitable intentions are met, sometimes even centuries after the trust was established?
Charitable trusts are indeed a very special category, primarily distinguished by their public benefit purpose and their potentially perpetual nature. A key principle that comes through is that they must be for a clear and defined charitable purpose.
You stick to it.
Absolutely. The source provides a stark example. If a trust is set up to find a preacher for a specific church, it would be considered a breach of trust to apply it to the poor for general relief, even if that seems like a worthy cause. Similarly, a fund specifically established for erecting a hospital cannot be diverted to lighting, paving, and cleansing the town. The funds must remain dedicated to their specific charitable purpose.
No diverting funds, even to other good causes.
Generally not without specific legal authority. This is critical for maintaining public confidence in charitable giving donors need to know their specific intentions will be honored.
So there's strict adherence to the defined purpose. And how does the court oversee these trusts? Is it more hands-on than with private trusts where, as you said, they might respect a trustee's arbitrary discretion?
Oh, absolutely more hands-on. Unlike private discretionary trusts, where the court might be reluctant to interfere with a trustee's bona fide arbitrary power, the court actively supervises charities. It exercises a discretion as having the general government and regulation of charity.
What does that mean in practice?
It means the court can step in not just to ensure proper administration and prevent breaches of trust, but also to modify the trust's operational framework if needed. A key tool here is the doctrine of
Cypre, French.
Yes, French for as near as possible. If the original specified purpose of a charitable trust becomes impossible or illegal, or perhaps completely impracticable to fulfill over time, the court can use the Cypre doctrine to redirect the funds to another charitable purpose that is as near as possible to the original donor's intention.
So the money isn't just lost if the original charity closes down, for example.
Exactly. It ensures the underlying charitable intent is preserved and the funds continue to serve the public good, even if the exact original method is no longer viable. It's a proactive supervisory role, ensuring charity property is stewarded effectively across generations.
What about selling off charitable property, like land owned by a charity? Is that allowed, or is it considered too vital to the charity's long-term existence to be freely alienated or sold off?
Generally, trustees of charities cannot just alienate or sell charity land without specific authority. Historically, this often required an act of parliament, which underscores the uniquely public nature of charity property. It's not simply private assets to be freely disposed of by a board of trustees whenever they feel like it.
Are there exceptions now?
Yes, there are more modern mechanisms. For example, sales might be sanctioned by the charity commissioners or the relevant regulatory body today, but usually only if the sale demonstrably benefits the charity. For instance, selling an old, inefficient building to fund a new, better facility, or selling land to reinvest the proceeds into more productive securities to generate income for the charity's work. The goal is always to preserve and enhance the charitable purpose, not to diminish its assets through unwise sales. It's another powerful example of how the law seeks to protect these long-term, publicly beneficial entities.
Perhaps one of the most fascinating areas of trust law, and one that really reflects profound societal shifts, is how it developed historically to protect the property of married women. As you know, they historically had very limited legal rights over their own wealth once married. Can you give us some of that historical context that sets the stage?
This is truly a cornerstone of equitable jurisprudence, and it reflects a remarkable legal innovation, really, in response to what was a significant social injustice baked into the common law. Historically, under common law, when a woman married, she became what was legally termed a feme covert.
Feme, covert, covered woman.
Essentially, yes. Her legal identity largely merged with her husband's. This meant her property, both real estate and personal property like money, jewelry, investments, typically came under his control upon marriage.
He just took it over.
He gained significant rights. For instance, a right called curtsy over her real estate after her death if they had children born alive. And he generally took possession and control of her personal property, which he could often spend, invest, or dispose of largely as he wished, even against her desires.
That left married women incredibly vulnerable financially.
Absolutely. With little or no independent financial agency or protection against, say, a spendthrift or irresponsible husband, or even just against his business debts, it was a legal reality that often created immense hardship and dependency.
So, how did the law of trusts step in to address this fundamental imbalance and offer some protection? Was there a specific equitable innovation that changed things?
Yes, equity, specifically the Court of Chancery, developed a groundbreaking concept known as the separate estate or separate use. This was a crucial legal invention.
How did it work?
Property could be explicitly given or transferred in trust for the separate use of a married woman. The key was using clear language in a deed or a will that explicitly excluded the husband's normal marital rights over that specific property. The clear intention was to create a protected sphere of financial independence for her within the marriage.
Could anyone set this up? Her family, for instance.
Yes, typically her family would set it up before marriage in a settlement, or perhaps through an inheritance. What's even more remarkable is that the source notes even a husband could, in theory, make himself a trustee of property for his wife's separate benefit, holding it separate from his own general marital rights. The creation of the separate estate by equity was a radical departure from the common law and provided a vital avenue for protecting women's wealth.
And what powers did the wife have over this separate estate? Was she truly independent in managing it, like a single woman?
Yes, that was the revolutionary aspect. Over her separate estate, she was treated in equity as if she were a feme sole, meaning as if she were a single unmarried woman in relation to that property.
So she could do what she wanted with it.
Largely, yes. She could enter into contracts regarding it, purchase property with it, sell it, lend money from it. The source even mentions she could lend money to her husband from her separate estate and dispose of personal property held to her separate use by simple manual delivery, just like anyone else. This equitable invention allowed women of means to maintain financial independence within marriage, providing a vital shield against their husband's debts, improvidence, or just his absolute control. It ensured that at least some portion of a woman's assets remained truly her own.
That's a huge step forward for women's property rights, achieved through the mechanism of the trust. But the text mentions another layer of protection that was often added, called the restraint on anticipation. What was that, and why was it felt necessary to add this on top of the separate estate? It sounds restrictive.
The restraint on anticipation was indeed an ingenious, though some might say paternalistic, addition designed to provide even stronger, almost foolproof protection. It was a unique clause that could be added to the gift of separate estate.
And what did it do?
It essentially prevented the wife from selling, mortgaging, charging, or otherwise disposing of her separate property in advance of the income actually becoming due and payable to her. She couldn't access the capital, nor could she assign or promise away future income payments.
Why? What was the purpose of locking it up like that?
Its primary purpose was to protect married women not just from their husbands exerting undue influence, but also potentially from their own improvidence, or perhaps more commonly, from being pressured by desperate family members or creditors into alienating their future security. It ensured they had a continuous income stream or a capital asset that couldn't be frittered away, signed away under duress, or lost in a single bad decision.
So it made the property inalienable and inconvertible during the marriage.
Exactly, as the source notes during coverture, the period of being married. The court generally upheld it fiercely as a safeguard. The idea wasn't, as the text says, to enable her to do a wrong in the court, but to genuinely protect her long-term financial stability, acknowledging the very real societal vulnerabilities and pressures women faced at the time.
So how did all this complex system of separate estates and restraints change with the Married Women's Property Act of 1882? Did that act just sweep it all away and make these trusts completely obsolete overnight?
The Married Women's Property Act, 1882, had a profound and truly transformative impact. It's often considered a landmark piece of legislation for women's legal and economic rights in England.
What did it do specifically?
It enabled every woman married after the commencement of the Act, which was 1st January 1883, to hold as her separate property and to dispose of by will or otherwise all real and personal property, as if she were a feme sole, without the intervention of any trustee.
Without a trustee. So the law itself now recognized her separate ownership.
Precisely. This was a monumental shift. It largely made the equitable invention of a separate estate trust redundant for new marriages, as the law now directly recognized married women's independent property rights as the default position. No longer did a trust necessarily need to be set up just to ensure her property remained hers after marriage.
But did trusts for married women disappear entirely?
Not necessarily. Old trusts established before the Act remained subject to their original terms, including any restraints on anticipation. And trusts continued to be used for married women and men for various other reasons beyond just basic ownership, complex family settlements, managing assets for minors or those unable to manage their own affairs, tax planning, protecting assets from creditors for other reasons. So while the specific necessity of the separate use trust diminished dramatically, the overall relevance of trusts in family and financial planning certainly didn't vanish. It marked a major evolution, not an eradication, of the trust concept in this area.
Okay, one last area here under the dynamics of trusts. What about claims from outside the family? Things like creditors trying to recover debts, or even the Crown making claims. How did equitable interest held in trusts stand up to these external pressures historically, and how did the law evolve?
Right. This is where the distinction between legal ownership held by the trustee and equitable ownership held by the beneficiary becomes very practical and often a matter of legal power and reach for outsiders. Historically, common law methods for enforcing debts, like the writ of eligit, which allowed a creditor to seize land, were designed to grab legal estates' outright ownership.
So they struggled to get at the beneficiary's interest hidden inside a trust.
They initially struggled, yes. It could be much harder to enforce a judgment against an equitable interest compared to a straightforward legal title. This created a kind of loophole where a debtor's beneficial interest in a trust might be somewhat insulated from their creditors, making it harder for debts to be collected, especially from complex trust structures.
So if your assets were cleverly placed in trust, they were harder for creditors to get at. That sounds like a big advantage for debtors, though maybe unfair to creditors.
It could indeed be a significant advantage for debtors and a source of major frustration for creditors. However, statutory changes gradually chipped away at this protection and addressed the imbalance.
How so?
The Statute of Frauds, way back, in its 10th section, allowed for some execution against simple trusts where the trustee just held bare legal title. But it didn't effectively cover more complex trust structures or diverse forms of equitable property like interests in money funds.
So later laws were needed.
Yes. More significantly, legislation like the 1 and 2 Victa C. 110 in the 19th century made judgments a direct charge on all types of equitable interests the debtor held, including interests in land, both freehold and that historical copyhold tenure, and money held in trust.
So creditors could now place a charge directly on the beneficiary's interest.
Yes. But crucially, that act also included a proviso that the protection and equity of purchasers for valuable consideration without notice shall not be disturbed. So it balanced creditor rights with the security needed for property transactions. We also see the introduction of specific tools like charging orders for stocks and funds held in trust, allowing creditors to put a formal charge on a debtor's beneficial interest in those financial instruments.
What about the Crown's rights? particularly in more extreme cases like forfeiture for treason or this concept of escheat, where property reverts to the state if someone dies without heirs. How did equitable interests fare there? Were they treated differently from legal estates?
Forfeiture for high treason was a very serious matter, and generally equitable interests were subject to forfeiture to the crown, often confirmed by specific statutes, like one from Henry VIII's reign, 26H8C13. If you committed treason, your beneficial interest in a trust could be taken by the crown.
Okay, so no shield there. What about escheat?
Escheat was a different and particularly interesting historical quirk. Escheat occurred when property reverted to the crown or the feudal overlord because an owner died without any legal heirs to inherit. Historically, under common law, equitable interests did not escheat.
Really?
Yeah.
So what happened to the property if the beneficiary died with no heirs?
This created a peculiar loophole. If a beneficiary of a trust died without any heirs, the equitable interest simply vanished, but the trustee still held the legal estate. Since there was no beneficiary left to enforce the trust and the crown had no claim via escheat, the trustee could actually keep the property for their own benefit.
Wow. The trustee got a windfall just by being the legal owner when the equitable owner disappeared without heirs?
Exactly. It was a significant anomaly where the trustee could profit purely by the accident of the beneficiary dying heirless.
That seems pretty unfair to the crown representing the state. How was that eventually rectified?
It was indeed seen as a major anomaly, and it was addressed by later legislation such as the Intestates Estates Act 1884, 4748 Viction C71, and subsequent acts. These laws directly targeted this loophole.
What did they do?
They essentially made the law of escheat apply in the same manner as if the estate or interest, the equitable one, were a legal estate. This ensured consistency. If an equitable owner died without heirs, their interest would now revert to the crown, just like a legal estate would. It closed that accidental windfall opportunity for trustees.
So it aligned the rules for legal and equitable estates in that regard.
Precisely. And generally, the rules for how a trust interest descended on intestacy, dying without a will, also followed the rules for the equivalent legal estate, for example. Copyhold trusts followed copyhold customs of descent. It shows this constant legislative effort over time to harmonize and rationalize the law, bringing equitable interests more closely into line with legal ones for many practical purposes, like debt, forfeiture, and inheritance. Hashtag outro.
Well, we've certainly journeyed through some deep and complex territory today, guided by this fascinating 1888 text on the law of trusts. We've unpacked the foundational principles, haven't we? From those nuanced provisions for families like portions and the tricky portionist dilemma.
Right, through to the incredibly strict, unwavering duties placed on trustees, especially that fundamental no self-dealing rule.
Yeah.
We really saw the weight of that fiduciary responsibility.
We also explored the evolving rights of beneficiaries, their right to information, to control, how they could even assign future interests. And then the special worlds of charitable trusts, their endurance, and how the law ingeniously adapted over time to protect the property of married women.
And how trusts interacted with those external claims, too, from creditors and even the crown, with concepts like forfeiture and escheat. It covered a lot of ground.
What truly stands out, I think, is how these historical legal texts, which might seem dry or irrelevant at first glance, actually offer a profound and often a really surprising look into the enduring challenges of managing wealth, family obligations, and power across generations.
Absolutely. They highlight that delicate balance of power and responsibility, and how legal principles evolve sometimes slowly through court decisions, sometimes through quite dramatic legislative shifts like the Married Women's Property Act, constantly trying to meet the changing needs of society.
It's really about how we define ownership, how we try to protect the vulnerable, how we ensure intentions are honored, sometimes centuries later, and even how the law adapts to unexpected turns of fate, like an heir dying young.
It reveals these deep societal principles woven into the very fabric of our legal system. These rules aren't just abstract. You can see how they were born from very real human challenges and dilemmas.
So the next time you hear about a trust, whether it's a centuries-old family estate managing land and titles, or a modern charitable foundation funding research, or even just some complex financial arrangements set up for a relative, perhaps you'll think about not just the financial details,
but maybe also the deep historical and societal principles woven into its very fabric, the weight of history behind it.
Exactly. It's a reminder that many seemingly modern concepts, structures we use today might have these incredibly deep, sometimes surprising roots in legal history, just waiting there to be uncovered. And perhaps that leaves us with a thought. What other seemingly modern ideas or structures might have such deep, unexpected origins in the long evolution of law, just waiting for a deep dive?